SJC-11917, Commonwealth v. Onyx White.
Good morning, Ms. Campbell. I think Martha's Vineyard has left us, so I think we're all set to go.
Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth.
Could you wait just a second? 'Cause
Sure.
I'm being distracted by the noise. Thank you.
No problem. We ask you today to overturn the judge's order suppressing a photograph that was found on the defendant's cell phone. I'll start first at the most, at least to me, logical place to start, which is the seizure of this cell phone. And I want to be clear about what the Commonwealth is arguing and what we're not arguing. My brother's brief and the amicus brief spend a lot of time talking about students' rights in schools and abandonment. The Commonwealth isn't contesting that the defendant had a reasonable expectation of privacy in his cell phone as it was held in the school, or that the school administrator was a state actor.
Explain, but you still need to, but you're arguing you had probable cause.
Correct.
And an exigency.
Correct, and that it alternatively could be considered a plain view seizure.
Explain probable cause. Because there were more than one person involved in the crime, they probably spoke on the phone, therefore there's probably evidence on the phone, is that it?
It's more than that, Your Honor. It's more than that. I think in this case, you have to consider the nature of the crime itself and the nature of the investigation itself, which in this case is not just one murder robbery, it's a string of robberies that has occurred over a 6-month period. The string of robberies that occurred over a 6-month period involved descriptions that matched the defendants and his 2 other joint venturers who he committed this joint venture.
And that was known?
Was he charged with those other offenses?
No, but you have to consider the investigation at the time that it was, what
They
the police
were all
uncovering.
connected by the police on February 24th?
Correct. By February 24th, they were. If you look at the record appendix, which includes the exhibits that were before the motion judge, a number of police reports that detail the timeline of the investigation do detail exactly what the police knew in the days after the murder.
And was there anything, there's this particular event on February 21st, but with respect to the group of them, any evidence of cell phones being used?
There is evidence in one of the murders of a convenience store that happened sometime before that they had stolen cell phones from that convenience store, but there's no evidence as to the defendant specifically had used this as an implement, as a implement of any of these crimes.
And nobody was seen on the phone, nothing?
No, Your Honor. No, Your Honor. So you have this string that has occurred over a period of time. More than that, though, you have a group of young individuals that are participating in a joint venture. And
Since all kids use phone, therefore probable cause? Is that
not if that was the only fact, then I think I'd be on different footing. I don't think that's the only fact, but I don't think that fact can be discounted. As Your Honor said in the first Augustine decision, cell phone usage is ubiquitous in everyday life.
That doesn't make probable cause.
It doesn't, but when you look at probable cause, it considers the practicalities of everyday life. And one of those practicalities is that people use cell phones to communicate with each other. Now, I'm not saying, I understand that, and there has to be a balance between what is the real life implication of this, what happens day to day with people, but also you have to balance that with what the police have to do to gain access to that information.
Well, you're not suggesting that we should start basing probable cause on what people do as a matter of course
Your
every
Honor,
day. That can't be right.
If you look at O'Day, which I think is the best articulation, the actual standard of probable cause says that you can look to common sense explanations to the practicalities of everyday life. I'd say inherent in that probable
I
cause.
get that, but that doesn't mean that because I walk out of here with a cell phone and that's considered to be normal, typical behavior, that is part of the probable cause calculus.
Yes,
Just
it
because
is.
people do something that's normal.
Your Honor, I'd say that that always has been part of the probable cause calculus.
Normal behavior is part of probable cause, which means that you believe that somebody has committed, or is about to commit a crime. Normal behavior leads you to that.
Sure, and I don't think that
So is there any boundary in every single criminal case?
Sure.
On your theory, you can always get a search warrant for somebody's phone because everybody uses phones.
No, I think when you're looking at, you still have to look at the nexus. So I think there's a difference here between, we really should take it step by step. You have to look at the seizure, and then you have to look at the application for the search warrant, and then because a timeliness issue is raised, we have to look at that. But when you're looking at the actual seizure, it's whether there's probable cause, which is a probability based on the practicalities of everyday life, whether the police had reason to believe that this could be evidence. And it's not just if you look, and I urge you to go back and look at the probable cause, what's written in the actual probable cause standard, because you're looking at me
Are
skeptically.
you suggesting I haven't read it?
No, I'm not, but I think I'm urging you to think of not,
Or
I
maybe
think-
we need to change it if that's the way you think.
So
Your Honor, I would say that you don't need to change it because
I mean, the
it's
part that I'm
words.
struggling with here is you probably would have had probable cause if what you did was you grabbed that phone and you immediately found out what the telephone number was of that phone and then searched for cell phone location information. Because that would have identified the location at the time of the alleged crimes. But you didn't do that. So how does that bear on the issue of you might have had probable cause if somebody was clever enough to have used it, but you didn't even seek to find out what was in the phone for another
Sure.
70 days or something like that?
Well, I think your example is a good example because you say you would have had, it assumes that the police could have seized it at the first instance because they,
Just to get the phone number?
well, we don't know the phone number in this instance. I mean, when you're considering it, you have to consider that this cell phone is like any other piece of evidence. I know that it has the capabilities to reveal a lot of information, but we're not saying that the police can obtain that information without going through a neutral and detached magistrate. Our argument is not, we have probable cause to seize, therefore the police can go into the phone and search it at will. That's not our argument
you
at
have
all.
to have probable cause that there is information in the phone, evidence
Correct.
information in the phone relevant to a crime.
Correct.
All right, so you've got, the defendant has a phone. You know, based on your investigation, that there are several people involved in these crimes.
Yes.
Anything else?
We know that the defendant, that there are two other individuals. We have some information about location, where they may live in relation to where the defendant lives. We have some information about their identities. My brother includes 2 police reports in his supplemental record appendix. Those were never put before the judge. Those weren't evidence before the judge. I'd say that the identities of who this individual, who the defendant was committing these robberies with, that would reveal evidence of the crime in and of itself. And the police don't have...
But it goes back to, because the defendant had a phone, and since people usually use their phones to contact their friends,
Sure.
if we got the phone, we might find out who his friends are. Is
Well,
that
it's-
probable
it's-
cause?
I think it is. If you think of it in terms of a house, and if you consider it and look at Lefebvre. Lefebvre, when it gives the example of a plain view seizure, when it talks about what you can seize as evidence, it says,
Have a house, and you know
Yes.
that the defendant lives in the house, and geez, people used to write letters to their friends and get letters from their friends, so do we have probable cause to search the house for the
No,
letters?
I'd say that if you have probable cause if the defendant, and again, this is in Lefebvre, that he's working in a joint venture, you don't have conclusive evidence about the identities of who he was working in a joint venture with. They say if he has an address book that lists his contacts, you can seize the address book.
You can get a search warrant for the house to look for his address book to see who his friends were so you could maybe connect it to a joint venture? That's probable cause?
I believe it is. And if you look at probable cause in the search of a house, let's say you ask for identifying information because it's known that individuals who live in a house keep identifying papers there. It's in search warrants all the time, and it doesn't get struck for lack of probable cause.
But usually it's combined with something else.
Sure, usually it is. Usually it is. But here we're not talking about going into someone's house and seizing. We're talking about an item of evidence that was in the possession of a third party.
So I'm back to my question.
Sure.
On your theory, where are the limits of this? Every joint venture, you get every phone you could possibly think of, correct? Or anything that's maybe a joint venture, not even every joint venture. Maybe there's somebody else involved. Gives me probable cause to get the phone?
I don't think you can say maybe somebody else is involved. I think you have to consider what the probable cause for the crime is. And here, there's definitely probable cause to believe that he was participating in a joint venture based on the defendant's own statements, which were, we went to go commit a robbery. Martin had a gun, it went down, it wasn't supposed to go down like that. But I also think you have here, additionally, what you have is in the aftermath of this crime.
These are statements that his mother told the police. Is that what you're talking about?
These are statements that his mother told the police on 2 separate times.
All right,
First
but when were they? When did she call her friend that was the police officer?
Sure. If you look at the timeline, the murder happens on Sunday at about 10:30 in the morning. The defendant tells his mother about that the next day, Monday, around 1 p.m. She then calls her friend, who's a police officer, I believe 5 p.m. that day, so it's the day after the murder. She then speaks to the police Tuesday at 9:30 p.m. that evening.
So that's the 23rd?
That's the 23rd.
Can I focus on timing?
Sure.
I mean, the issue here is really his nexus. This is probable cause nexus, because there's abundant probable cause to believe he committed
Yes.
the crime. Do we examine the nexus as of the time of the seizure? So we look to what happened right then, and do we look to what the officers intended or understood the nexus to be? If they had obtained a warrant that day, they would have had to articulate the nexus.
Yes.
How do we evaluate? Do we evaluate what the officer or officers understood to be the nexus as of the date of the seizure?
No, I don't think the officer's subjective intent as to that time would control.
Okay, so how do we examine? I mean, do you agree they had to have a nexus to seize it?
Yes, yes.
Okay, so how do we examine what that nexus was when we don't have the advantage of a
search
prompt
warrant.
search warrant affidavit?
Here, I would urge the court to look at Detective Monroe's testimony, in which he testifies about the progression of the investigation and also his training and experience as it relates to cell phones.
And what does he say is the nexus? So does he articulate the nexus
He
there?
does, yes, he does articulate the nexus.
That
This is in by the afternoon of February 24th. That's what we're talking about,
Yes,
right?
yes. And I specifically leave out any information that we gained afterwards in my brief in the analysis of it.
So what is the nexus again?
Sure. The nexus is that there is a series of robberies that are a series of joint venture robberies that it is the defendant working with at least 2 other people. We know the 2 other people that he worked with on the day of the robbery murder.
And you know their identities?
We knew that one was a person who lived 2 doors down from his grandmother in a blue house named Martin. We also knew that the defendant, by the time he spoke with his mother on Monday, the day after the murder, was very fearful of Martin. He had a lot of fear. We also know that at least on Monday and Tuesday, the defendant was not staying at his grandmother's house, so he was not near where these...
So how is that nexus if this is all stuff they learned afterwards?
This is stuff that they learned before they seized the cell phone. They seized the cell phone on Wednesday at around 2 p.m.
So I gather that nowhere in his affidavit does he say, I couldn't be sure I could identify the cell phone number of this phone, and I needed the cell phone number of this phone to get CSLI, and therefore
Not,
That's nowhere there.
that's not in the affidavit. It is in the, if you look at the report of the mother when they interviewed her on Tuesday at 9:30 p.m., they do ask the mother, does the defendant have a cell phone? She says, yes, he has a cell phone. I know it's a pay-as-you-go phone.
And he's out of minutes.
I know that he ran out of minutes last night.
Okay, but does that have to, the fact that she said that, does it not have to be incorporated into the, I mean, if the officer had done an affidavit right then, we would
Sure.
look to the four corners of the affidavit. We wouldn't say, well, actually, there was stuff he didn't include in the affidavit that you should consider.
Sure.
So how do we evaluate it when he doesn't, he can't be better off for not getting a warrant immediately?
I understand that. I think you view it as in terms of the same way you would view any warrantless seizure of an item, in which you look at, again, what was known to the officer at the time. I think if you do look at his testimony of Detective Monroe, and I'm not positive of this, but he does speak of that interview, and I think he does speak that the mother didn't remember the phone number at that time.
Why should we be thinking about warrantless searches? He could have gotten a warrant.
The seizure of itself was warrantless.
I know, but why?
Sure, and that's an important point, actually. I think it's important for the court to consider this because in Riley, the Supreme Court does talk about steps that the officers can take to secure a cell phone. So the question is, when officers are presented with an item that could conceivably be evidence, which I argue, have probable cause to believe is evidence, what are they supposed to do? Do they have to freeze it in the same way that you would freeze a home? Or can they seize it and then get it pending the issuance of a search warrant? And I'd say that...
In this case, it was pretty easy to freeze right in the school. All they had to do was say, don't give it back.
But there's nothing, I mean, they can't compel...
They could have
Well, they could have
stayed long
tried.
enough to just go to the nearby courthouse and get a warrant for it.
They could do that. They could do
They
that.
could do that.
But I think when you look, there's no other instance, at least that I could find, where the court has required, aside from a home, which has the utmost protection underneath our laws, in which the officers are required to freeze an item. And
But you do agree that the phone itself has a whole lot of very private information. So freezing, the fact that it's located in a school seems less important than that it's a phone.
I disagree with that, Your Honor, because yes, if the police officers were then just going to, instead of freezing it, search it. But that's not what they did here. They just took steps to secure it. And I'd say that that's different than
Securing
seizing
it is not seizing it?
Securing it is seizing it, but securing it is definitely...
Don't you have to have some probable cause at the time to seize it?
Yes, which I argue for all of the reasons.
And I'm not hearing the nexus.
And I believe that I've articulated it. I'm not going to go through it again as I see my time is up, but I believe that there is a nexus, and here where the police froze it, they didn't go into it and search it. If you look at Riley, it talks about the reasonable steps that police officers can take to freeze a phone, which is what they did.
For 68 days?
That's a different issue. As to that issue, I'd say that it wasn't raised by the defendant below. We certainly would like the opportunity to present more evidence as to what the police were doing during those 68 days. I'd say that they were more than diligent in their investigation given their responsibilities at that time, which is something that the court should consider. And I see that my time is up. If the court has no further questions, the Commonwealth...
Well, I do have one more.
Okay.
As I understand it, the affidavit that was ultimately presented in April or May focused on the fact that there was now the information that there would be a photograph or photographs on that phone that showed the defendant holding up money.
Yes.
Was that the basis? I haven't looked at the affidavit. Was that the basis of the probable cause?
That was the basis. I don't want to say that's the only basis of the probable cause, but that was the basis they presented to search the phone specifically.
So
for
does
the
it not
photograph.
matter what the actual, ultimately, when they finally got a warrant, doesn't it matter, shouldn't it matter to us what the warrant said?
I don't believe, no, and I'll tell you why. No, because even if you were to excise out the portion that talks about the photograph, Even if you were to excise that out, and I think you should set aside the subjective intent of the officers when they apply for the search warrant, even if you were to excise out that information, it's still our contention that there was sufficient probable cause, at the very least, to gain the identifying information and any kind of evidence about contacts or communications. It's really a limited type of probable cause that the Commonwealth is urging that the police had here in terms of nexus. It's not for the entire cell phone. It's not to look for every single file. It's limited to identification information and communications. And that's the probable cause that they had at the time that they seized it.
All right, thank you.
Thank you.
May it please the court. Good morning, Mr. Chief Justice and members of the court. My name is J.W. Carney Jr., and with my colleague, Attorney Danya Fullerton, we represent Onyx White by appointment in the trial court. In the American colonies, one of the greatest abuses that people had to put up with was the belief by government agents that they could search a person, her property, her papers, merely on speculation that there might be evidence there. The writs of assistance were called by James Otis.
We only have 15 minutes, so we don't want to go through all 200 years of our history. I'm
going to move quickly.
But that's good. But I'm going to move you. Let's imagine, put aside the seizure issue, let's assume that this officer, either immediately after seizing it or before, had put together an affidavit which says there's information from the mother that he had a pay-as-you-go cell phone. Those are really hard to identify the owner of it. There's reason to believe that he had this cell phone at the time of the crime, and being able to get the telephone number off the cell phone and then search for CSLI, the location information from that cell phone would help to identify that he was at that location, in fact, multiple locations at or about the time of the crime. Probable cause, nexus?
No, Your Honor.
Why
First,
not?
one fact that you mentioned that is not present is having a reasonable belief that the phone was with him. Indeed, there was a phone at school, and when he was arrested later on the 24th, he was in possession of a second phone. So
But
there's
this was
no
the,
direct
this was
evidence
the
that he
Sunday
had a-
before. This was the Sunday before. Right, I
Yes.
mean, so I'm just, if you take what the mother said, and my memory is that the mother said had said he'd run out of minutes the night before. So I'm assuming that's Sunday night.
Yes,
right?
the 23rd. Or the
21st or
22nd,
something.
if it would be the night before.
Okay, so, I mean, we have Riley that says it's almost, a Martian would say, it's an appendage of our person. We can't infer that if he had a cell phone with minutes at the time of the crime, that there's probable cause to believe he was carrying it.
No, Your Honor.
We need to have evidence that he was carrying a cell phone in order to get that information?
You need to have evidence that a cell phone was used in the planning, commission, or concealment of the crime.
Why not the fact that the cell phone may identify his location at the time?
Because the fact that everybody, or almost everybody, has a smartphone does not mean that that alone is enough to contend that it has evidence of a crime being committed on it.
Okay, let's imagine that there was a terrorism, the concern potentially that this may be a terrorist incident, and the police are concerned about identifying possible co-conspirators, seeing if he acted alone. They can't seize the cell phone. They can't search a cell phone. And if they can do it then, why can't they do it here? We don't have a terrorism exception for probable cause, especially when it's not even clear whether there is terrorism.
Based on my experience involved in cases of alleged terrorism in the federal court, I respectfully disagree. It does appear there's a terrorism exception as to how far the government can go to search involved in cases that do handle terrorism.
So
What
we,
we're talking about
should we
is,
articulate that? I mean, I assume right now the FBI, I'm sure in California, one of the first things they did was to grab that cell phone and to search that cell phone. Illegal?
terrorism is different, and I'm not going to comment on
Okay,
what's
well,
going
I
on in
understand, but I
San
mean, but a
Bernardino.
crime is a crime, and I don't know that we have articulated, I mean, is our jurisprudence to be that we're going to have ordinary crimes and potential terrorism and have a different standard for probable cause for each?
No, we're going to hold to the probable cause standard that has served us well ever since it was articulated. When Article 14 was created for the Declaration of Rights, it was banning unreasonable seizures, not just of a person or her home or her papers, but also her possessions. Unless there was, and the way the reasonableness has been determined is whether or not there is specific probable cause in this situation that indicates that the phone was used in the context of a crime. Look at the slippery
But
slope
how about
we're
whether
on
the
here.
whether it may contain evidence that may support, or that may evidence of a crime, or evidence that may lead to the solution of a crime? Is that not a reason for a search?
Look at the slippery slope we're on here. If a person could have evidence on his smartphone that could be evidence of the crime, even if you're just engaging in speculation and conjecture, as Your Honor is doing, well, he might also talk on the phone. So why not permit a wiretap to be set up? He may keep things in his home, maybe the proceeds of the crime. So because he lives in a home, let's find probable cause to search the home because it could possibly have evidence. That's the direction we're going if we're not going to hold the probable cause standard for smartphones. Indeed, as the Supreme Court
no
noted,
one is suggesting that there's not to be a probable cause standard, and no one is suggesting that the issue is not probable cause to believe that he committed the crime. I don't think that's in dispute. The issue is probable cause of nexus. You're purely a nexus issue here. And so the question is, what constitutes probable cause? Is in a drug case, when you have reason to believe that maybe the drugs are there, or that money is stored there, that's nexus.
you can apply that to every single criminal act, whether a joint venture or an individual committing a crime. It's the same. If he has a phone and he has a telephone and he has a home, well, any of these things could possibly contain evidence. And what this court has done is looked at the specific evidence that suggests something would be there. For example, the court has stated many times that probable cause that a person committed a crime does not justify a search of a home in the hopes that some evidence of the crime might be found there. Similarly, probable cause that a person committed a crime doesn't justify search of his office or her office unless there's specific indications. Similarly here, unless there's specific information indicating that a cell phone was used in the commission of a crime, that cannot
It was
constitute.
used in the commission of the crime, meaning there has to be evidence that the telephone call was used during the crime?
Or in the lead up to the crime, or in the aftermath of the crime. And in fact, the lead detective
In the
was
aftermath
asked,
of the crime, meaning what? Meaning that concealment of what? Of the concealment of, I don't get you.
concealment of a gun, concealment of proceeds.
Cell phone would demonstrate concealment of a gun?
If people were texting back and forth, that's the speculative aspect of it. That's saying, well, maybe
So that would be enough, that the mere fact that he was texting after the crime would give you the nexus, because that maybe those texts concerned concealment? That
No, I absolutely disagree with that
Okay, so
proposition.
I'm trying to understand, I understand, in this case, you're well positioned because the fact of the matter is the police didn't, as far as I can tell, probably did not articulate an appropriate nexus. But the question is, how far do we go along these lines? How difficult do we make it to obtain, to show nexus for a cell phone? And What you're saying is a very, very narrow focus. To mean to be used in the commission of a crime as opposed to may contain evidence of a crime appears to not be consistent with our jurisprudence.
The detective in this case was specifically asked during the hearing whether prior to his seizing the phone, he had any indication whatsoever that a phone had any relationship whatsoever to this crime, and he said no. Judge Brady agreed that that was the state of the evidence and found as a fact there's no suggestion that the person had a phone or used a phone in relation to the commission of this crime. Just the fact that a person has a phone, a smartphone, is in the same category, I submit, as the fact that a person has a residence where he lives. Yes, he lives someplace. And if he was involved in stealing something from a store, maybe the stuff is at his home. So we now get a search warrant based on that because he lives in a home. Well, the suggestion by the government is because a person has a smartphone that could possibly contain some evidence that would be related, well, that constitutes probable cause. And I submit that conjecture and speculation has never been sufficient to establish probable cause. Another consideration is what a smartphone represents. Because in terms of analyzing the reasonableness of the search, this court has explicitly said that the item to be searched is a consideration for how the search needs to be justified. For example, in the context of a home, where the government says is entitled to the most protection. Well, I submit that right now, a smartphone can provide more information about an individual, including intimate information, financial information, where you've been, where you're going, what your plans are, who your friends are. The smartphone has so much information that you get more from that phone than from the house.
Could you, is there anything to be gained from getting the phone number? If there's no other way to get the phone number, can you get the phone to just get the phone number?
I don't think you can seize that without probable cause.
And the phone, and what if, I mean, I think Chief Justice Gantz's argument is you get the phone number because then the phone number is going to enable you to get a search warrant for CSLI, and there would be probable cause to get the CSLI because, at least the argument would be, because they know that they have information that this particular person was involved in the event on February 21 and a series of other criminal incidents. So can you do a two-step process like that?
The police cannot take the phone without it being a seizure that requires probable cause. And they can't turn on the phone and see if there's a number without having probable cause to do that search. It stops.
But I think the argument is if just assume hypothetically that based on the information that they have, that if they had the number, if they had the phone number, they would have probable cause to get a warrant for the CSLI. Assume that. Mm-hmm. Does that fact give them probable cause to get the number if they don't have it?
No, Your Honor, it doesn't.
Because?
Because there's no probable cause that the phone was involved in the crime. I mean, it gets back to having a smartphone. And all of the arguments that I'm hearing by the government and the questions from the court presume that because a person has a smartphone, then that smartphone could potentially contain evidence. that we can use to advance our investigation. Well, they can't, under that circumstance, seize the phone without probable cause that the phone contains evidence of a crime, and search the phone for the phone number without probable cause that smartphone contains evidence of a crime. Because basically what you're doing is taking these steps without probable cause and invading the privacy and possessory rights of the defendant. If you're going to say that the mere possession of a cell phone gives an opportunity to find some evidence on it, such as location evidence, and that justifies the police seizing the phone, looking at the phone number, and then following up on it, and that's all encompassed in probable cause, well, members of the court, you are very rapidly going to see in every instance when a person is alleged to have committed a crime, the phone will be immediately seized. The number will be looked up, and everything at that point, once a search warrant is obtained, is now open to the police. It's not a targeted search in these cell phones.
That's what you're speaking. The question is, what's the scope of the search that's going to be permitted under the warrant? That's a separate issue.
It's a separate issue, but based on years of experience of when the police get these search warrants.
The warrant would articulate that's a separate issue as to, under the example which I gave, what the appropriate scope would be for such a search, whether the scope would be limited to the telephone number or whether the scope would include going into contact information or texts or other things. You agree that you could limit the scope of a search of a cell phone pursuant to warrant.
Yes. But the realistic point I'm trying to make is that in every case, it will become standard protocol for the police to seize the cell phone and begin a search of it. And if that's going to happen, it will be based on abandoning the requirement of probable cause before you can search something as private as a smartphone. And I urge the court not to abandon that standard that has protected us for so many years.
All right.
Thank you.